I hope you're doing well too.
I'm fine, thank you.
I guess you know the trajectory of this particular case. Is the MPP right?
Sana, I don't know the reason for them going to the Supreme Court. I say so because when the Kpandai thing started, NDC candidate filed petition at the Tamale High Court immediately after the election results were declared.
Okay.
Then Honorable Matthew Nyingam caused a motion to be filed at the High Court to strike out the petition as premature. And in that instance, he deposed to an affidavit and attached a gazette notification which was dated 6 January 2025. So when that happened, NDC team quickly withdrew their petition and waited and refiled after the 6th January, which was the reason why the petition was filed around 25th January. So there is on record a gazette notification attached to affidavit by Honorable Matthew Nyingam. And today they are bringing another gazette notification, which is dated 24th, as it were, 24th
December. Yeah.
December.
Yeah.
You see, Sana, if your memory will serve you right, we had similar thing in the Akwatia case, where MPP had another gazette notification different from what we went to buy at Assembly Press. Until today, EC could not, in court, confirm that the one that they were displaying was, as it were, a forgery. To the extent that the Supreme Court judges told my senior, what's the name, Justine Amenuvo, that you are not helping us in this matter. And we are going to have another team we play again. Two different gazette petitions, all from MP. So I don't know what you think, Chief. I will put it down to only one thing, that the late MP, the Akwatia MP, if he had been arrested and cited for perjury by the Supreme Court, wouldn't have had this situation at the moment. Because there's no way. So in effect, this MP already deposed to an affidavit and attached, give me the word, and attached a gazette notification which was dated 6th January in Tamale. And today you are attaching another one to the Supreme Court one dated 24th January. Where are we?
So the first application you filed, the first petition you filed, they challenged the petition on the grounds that it was premature because the gazette had not been published at the site.
Exactly.
Okay.
Okay, and now, then they brought out the gazette notification that they feel is a genuine gazette notification, and we all agree to it. Then today, they are bringing another one, which is also a different date. So what is going to happen is that MDC lawyers will only go and pick, which they have copies already anyway, the affidavit that was deposed previously with the attachment, and show it to the Supreme Court to say, these were the guys who brought this earlier, and now they are bringing another.
But did you do your own checks? Was checks done by those who represented the NDC candidate that showed that perhaps the MPP was right with the gazette that he had published?
Come again, Sana.
I was asking whether you checked to ensure the team that represented the NDC candidate checked to ensure that that was the proper gazette.
Yes, you see, again, currently what will happen is that because the MPP guys put the other one in issue and it was in public domain, it was a court document, they can rely on it. That you brought this to us, and the court accepted it, and we all accepted it, and today you are bringing another one. So, but as we did in the Akwatia case, when we noticed that we couldn't trust them, we wrote to Assembly Press for verification. And I can tell your authority, we reached out to the NDC legal team yesterday to say that, hey, this is what we did. You can cross-check with Assembly Press and find out if genuinely that is the correct gazette notification they are displaying now. If that is it, then they will now ask the Supreme Court to ask them why they deposed to an earlier one and gave a different date. If it is that the Assembly Press confirms that the earlier one was the correct gazette notification, then the Supreme Court should ask them, why are you bringing this one here today?
I see. Very, 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 very interesting, because we all thought they were going to head to the Court of Appeal based on, is it the law that guided parliamentary election petitions? If you're filing an appeal, you're supposed to go to the Supreme Court, right? So, some form of education. You're supposed to go to the Court of Appeal.
Court of Appeal.
Okay. So exactly what are they doing in this?
Okay, what they are doing now is not, they are not appealing the ruling of the Supreme Court, of the High Court. What they are saying is that the High Court didn't have the authority, or what we call the jurisdiction, doesn't have the power to listen or hear the case. So all the hearing that took place in Tamale, the Supreme Court should quash it. The level of education here is that the Supreme Court has jurisdiction over all high courts. So matters such as this can be brought to the Supreme Court for the Supreme Court to quash it. So they are bringing it to the Supreme Court to quash. So they were not appealing. So it is not the merit of the case. So the government of their argument is that the High Court had no jurisdiction, yet assumed jurisdiction and heard the case. So that is fundamentally wrong. Now, as a bit of education, this relief they are seeking is a discretionary relief. Now, you can meet all the conditions, but your conduct is one thing that the court will pay attention to before granting it to you. Now, the court will ask, you took part in all this. You call witnesses. They also call witnesses. There was even the Electoral Commission. The Electoral Commission did everything. And now you are coming back to say you are now aware that the court has no jurisdiction. That is where it's going to be difficult for them to convince the court that they were not aware, yet they took further steps, or whenever they became aware, they took further steps and went through trial. Granted that the trial started in July till today, then you are now coming that quash it. The Supreme Court will take a second look at it.
And that's the point I was coming to, that usually when you monitor cases of this nature, this kind of matters are raised from the very beginning of the case. So where you feel that the person was out of time and had filed the petition out of time, usually don't you raise it with the High Court from the very beginning so that the matter does not move all the way to this stage before you are taking it to the Supreme Court?
Exactly. So they should have raised it at the very beginning and informed the court that, hey, you don't have jurisdiction to assume the case. And any other thing you do based on that will be quashed. Then when you raise it and the court doesn't want to listen to you, you could have gone then to the Supreme Court to prohibit the court or to prevent the court from even hearing the matter then. And they didn't do all that. And now judgment has been passed, or a judgment given. Now you want to go to the Supreme Court to say, now the High Court assumed a wrong jurisdiction, a jurisdiction it didn't have. The Supreme Court will ask questions to say, when did you know? And as you, Senna, you just said, I mean, a lay person, you are not a lawyer. You are asking this question. And the Supreme Court, that is made up of laws. They will ask the same question.
Thank you. Thank you very much for speaking to us. Of course, we'll be monitoring what will happen at the Supreme Court. Thank you.
You're welcome.
Well, so like last time when we spoke to him and we spoke to a few other lawyers, the education was simple, that election petitions, when it has to parliamentary elections, start from the High Court. They terminate at the Court of Appeal. So you cannot ask for a review of a decision or an appeal of the decision that a Court of Appeal will make. So you go to the High Court. If you don't like, you go to the Court of Appeal. Now, they have jumped from the High Court to the Supreme Court, and he explains that it's because they are raising a fundamental question of jurisdiction. that the High Court did not have the jurisdiction to raise this matter. I asked the question about why didn't they raise it at the High Court, because I recall famously in the Zaneto matter, Godwin Kujo Tamako was handling the case, went before the court and made a simple argument that the same matter of jurisdiction and also whether the matter, it was time to hear that kind of argument, that because what do you call it? The Electoral Commission are not open nominations. You cannot raise a question about the qualification of the candidates. Zaneto had just been elected as the parliamentary candidate elect of the National Democratic Congress for Klote Kole or Kole Klote. And I think the contestant, the other contestant in the case, who lost to her, raised the matter in the High Court, took it to the High Court and said that she was not a registered voter. God went before the High Court and argued severally. That's simple. This only applies if her name is filed as candidate of the National Democratic Congress during public elections. And we have not gotten there yet. So it is premature. It is not time to raise this issue. The High Court disagreed with him, I think on 2 occasions. So he decided to take it to the Supreme Court. So when he went before the Supreme Court agreed with him. So I was wondering, why didn't they raise the matter of timing? That the people were late. They should have filed, they were filing 11 days late. That you're supposed to file within 21 days of the publication of a gazette. That I know that the gazette was publicized on this day. So if it was publicized on 24th and you are coming 11 days late, the court has no jurisdiction to hear the matter. So raise it with the High Court. The High Court will listen to you. And then if the High Court still decides, you go to the Supreme Court and challenge it. This one, they've gone through the whole cycle, everything. And they've come full circle. The court has made a decision. Now that you've remembered that, they were late. And you are taking the matter to the Supreme Court. So it's quite confusing. Usually these matters are raised very early in the case so that you don't waste the time of the court. But